is Daniel Bornstein. I'm co-founding partner with the law offices of Bornstein and Bornstein, a real estate law firm that operates throughout the Bay Area in California. Our areas of expertise include real estate litigation with an emphasis on resolving landlord-tenant disputes, both in rent-controlled jurisdictions and in jurisdictions throughout Northern California. Today's subject is a subject that's very important for people who invest in real estate. If you're managing a landlord-tenant relationship, it may fail and you may be confronted with having to go through the eviction process. The eviction process, or an unlawful detainer action, is regulated under California law, which means that regardless of whether you're in Los Angeles, San Diego, San Francisco, or Northern California cities, the statutory rules are the same. The commencement of an eviction action typically requires a notice of some sort. It can be a 3-day notice to pay rent or quit, a 3-day notice to cure or quit, a 30-day notice of termination, or a 60-day notice of termination. What you need to recognize is that in unlawful detainer or eviction cases, the notice and the proper drafting and servicing of the notice is essential. You want to make sure you have a properly drafted notice that is actually time sensitive and is compliant with the current status of the law. Once prepared, you need to make sure you serve the notice correctly. Many tenant attorneys will actually cause you to lose your case and have to redo it simply because you have not drafted the notice correctly or served the notice correctly. It is my recommendation that if you haven't done this before, you go to an attorney and/or go to a licensed process server to make sure that this process is done accurately. If you serve a 3-day notice, for instance, to pay rent or quit, the tenant hasn't paid the monthly rent. If you serve that proper notice and the tenant pays the rent during that 3-day notice period, the matter is over. The tenant has, in fact, cured the violation, paid the rent. However, if the tenant did not pay the rent during the 3-day notice period, or in an alternative situation, you've served a 60-day notice of termination of tenancy and the tenant has not moved out of the premises, now you have perfected your right to prepare and file an eviction lawsuit. The tenant is unlawfully detaining possession of the premises, and that's why the name of this lawsuit is called an unlawful detainer action. Once you have filed the unlawful detainer action, remember, you cannot accept any further rent for the subject premises or you will lose the case because you have reinstituted the tenancy. What you want to be doing is at this point in time serving the lawsuit as fast as possible upon the tenant. There are many different ways to serve the lawsuit. However, oftentimes an individual who knows a lawsuit is coming will not allow themselves to be served. In that situation, you may get a posting order by the court. That will delay the case. Ideally, you're able to serve the lawsuit immediately. In California, if you personally serve the lawsuit, a tenant has 5 days to respond to the lawsuit. If the tenant, after 5 days, does not respond to the lawsuit, you can rightfully seek a default entry against the defendant, and if you do secure the default judgment, thereafter you'll be entitled to a writ of possession that will allow you to go to the sheriff and schedule the eviction from the sheriff's office. This would be the fastest and most expeditious approach to an unlawful detainer and the transition of a tenant from the premises. However, that's if the tenant doesn't actually respond to the lawsuit. If a tenant responds to the lawsuit, there are many different responses. One can be a pretrial motion called a motion to quash, where the tenant contests the service of the lawsuit. Another pretrial motion could be a demur, where the tenant challenges the drafting of your lawsuit or the drafting of the notice. If you lose those motions, you'll either have to start the service of the lawsuit again, or you'll in fact have to start the whole case over. The hope is, with the guidance of an attorney, that doesn't arise. If you win those motions, then the tenant will, upon receipt of the order, have to file a response to the lawsuit, typically within 5 days. Once the tenant does file a response to the lawsuit, that would be called the tenant's answer to the lawsuit, you are now entitled to file with the court a memorandum to set the case for trial. Once you have set the case for trial, the court will provide you a trial date and oftentimes provide you a settlement conference. It is my experience, after having conducted 20 years of lawyering in this area, that 95% of the time we're able to reach a resolution of the unlawful detainer action through a voluntary move out of the tenant. However, if at the settlement conference you're unable to reach a resolution, you are going to ultimately have to prove your case as the plaintiff to prove that you have properly complied with your obligations. The tenant need only defend themselves and alert or allege that you have not complied with your obligations. Ultimately, a tenant is entitled to a jury trial. If a jury rules in your favor, you will be entitled to an eviction action. If the tenant doesn't request a jury trial, there'll be a court trial. That's preferable. It's preferable because a court trial is shorter, quicker, and doesn't ultimately cost as much attorney fees time, because the actual eviction trial could be 3 to 4 hours at most. If you're successful in the court trial, again, you'll be entitled to proceed with a sheriff's eviction. However, if you're not successful, a judgment will be entered against you, and the tenant will be entitled to stay at the premises and may also be entitled to recover attorney fees. If you have a current ongoing landlord-tenant problem or have a question regarding your particular landlord-tenant situation, please give the law offices of Bornstein and Bornstein a call, or email us, or contact us through our website. We're happy to provide you education sufficient so that you can make good decisions about how best to resolve your landlord-tenant dispute.